Okay. So we're just talking about the what witnesses feedback really from having gone to court to support Baku. So one point that's been made is people need to be more assertive, and apparently the judge made this comment. Basically, you need to put. He basically said to him indirectly, or even pretty directly, you must be more assertive. But one tactic which is commonly used, and again was used there, is basically to take you down an alternative track. They look for a weakness, they spot the weakness, and then they'll try and remove your focus from your strengths, the actual good points. So in Buckle's case, it was basically intimating that the council's application included fraudulent documents. So, oh, are you saying that the liability order is fraud or a misrepresentation? Buckle recovered quite, without, because he was focused on it. He didn't allow the judge to take him down that track. And we're just saying that in the magistrates' courts, they'll use things like, well, who's going to collect the rubbish then? Or, what do you think? You don't have to pay and everybody else has to pay, and things like that. So what you need to do is really remain focused on the issue. And depending on what they say, you really can turn it to your advantage, especially in the council tax hearings, when the magistrates try stupidity like that. Because basically, by them asking you that question, who's going to pay for collecting the rubbish? Okay. What they're actually doing is moving out of law into politics. Okay. And the response is quite simple. Are you admitting that you're breaching your duty to the rule of law and breaching your duty to the separation of powers by turning this into a political issue? This is a court of law, and political issues are nothing to be decided in the court. So, along that effect, you can turn it around and basically shut them up quickly by mentioning again this issue of breach of duty. The judge's duty is to the law, it's not to politics. And basically what you're saying to them is, look, this is a court of law, not politics. And if you want to play politics, then you should become a politician and not be a judge. That is, in essence, what you're saying to them. But that, again, is needed to remain focused on the core issues. What else was there, Daniela? Is that about it, or Robbie?
I think that's basically it from the point of view of attitude. I was very surprised that the hearing was listed for an hour and it only lasted 35 minutes because the judge said you actually have 3 applications.
Yeah.
And he asked Bakul if he wants to go ahead with the others, and he said no.
Yeah.
Because I think he couldn't remember.
Okay. Yeah.
Which was, again,
unprepared. You want to go into the court prepared, knowing what it's all about. Okay, so, Rook, do you want to ask something in relation to this? Because
yeah, I would like to add that when he asks Buckles, when he says to Buckles, would you like to, because he'd thrown Buckles off path for a brief second.
Yeah.
When he presented something about disclosure, the last part of but what the judge was doing was shifting quickly from point that he had dismissed the case, the real inevitable part of the case. He didn't dismiss that with trickery. I felt over the weakness of Buckles. So he moved in and says, "Do you want to discuss this?" And was more trying to lure him in. And that at the point, Buckles looked through the paper. He says, "Yes, I'll continue," but he was going to dismiss that as well anyway.
Yeah.
Because he had already seen the weakness.
Yeah. Rock, have you got something to say about what's been said? Because I want to go on to then the reasoning.
I'm happy to wait. Actually, I was going to switch gears, but I have got nothing to add to what you've just said. Okay,
if you just come back after and then bring that point up. Okay. So again, the question to Robbie and Daniela, who were there. Do you feel the judge gave a reasoned explanation as to his ruling? What do you remember the judge saying as to why he reached his conclusion?
If I may answer, I think he didn't want to give Buckles a chance to actually read out what he had mentally prepared.
Yeah, no. I'm talking about the judge needs to give an explanation, a rational reasoning as to why he decided that the council's paperwork is good and therefore Buckles' application has been refused.
I felt it was 50-50 because Buckles had a point, but that wasn't heard, and the judge made his point, which I didn't think was on point.
Yeah, okay, I'll come back to that in a minute. Daniela, what did you think about the judge's explanation as to how he rationally reached his conclusion?
Well, it's very interesting because that brings me quickly to my really desire not to use believe. So from his point of view, he was trying to persuade us that this is what he believed. So he brought arguments as toward his belief, because this is what they do. They demonstrate this is what I believe, and that's why he came up with the decision. The fact that his decision and what he said was totally wrong and unlawful, it's another matter, because he was trying to persuade us that he believes that LOs were okay. He believes that so and so. So there is this discrepancy between what they are trying to persuade us that they believe and what the law and the reality is. And that's why I don't like using believe in documents.
Yeah, okay. Now I'm just scrolling back because I did make notes when people talk to me. Hang on, maybe I've got them here. Right. So basically, in his judgment, okay, his reasoned explanation, it sort of went something along the lines of, where have I got it? Referring to Buckles' application, saying the suggestions that it does not match the required evidential burden. Okay, and we'll come back to Leighton's judgment shortly. Okay, but basically his reasoning was Buckles' belief is simply untrue because this is standard documentation, which is entirely genuine and is not a questionable document. They're produced by the magistrates' courts. I've seen many thousands and things haven't changed for donkey's years. Does that sound like a reasoned judgment, a reasoned explanation? Or is that merely an opinion? Okay. So basically, that opens up for appeal simply on that sort of explanation. That is not a reasoned judgment, and therefore it needs to get overturned. It needs to get set aside. Now, we haven't decided how we're going to proceed with Buckles, but basically my gut feeling is the same as we're doing now with the magistrates court. Offer the court an opportunity to remedy the mistakes of its officers. And there's a number of reasons for choosing or preferring that approach. Okay. So what I want to do is, at the time, we had the latent judgment, and I can't remember if I put if we'd been to the Sharon's judgment, but just directly from the latent judgment, which was with the judge, I want to go through so that people really start to understand the difference between reasoned decision, or ratio decidendi, as they call it in Latin. It simply means you've got to provide a reasoned argument as to how you reached your decision. Because this, by the judge just saying evidential burning is simply untrue, standard documentation entirely, this is the judge's opinion. It's not based upon the evidence that was before him. And that this is not a reasoned decision. So, and this is something that we need to move into the High Court, and Calvin's fully aware of this. This is something Calvin and I have discussed quite a bit, okay? Because the judge's job isn't there to give his feeling of what the evidence says. His job is based upon the evidence to make an objective assessment of the evidence. Okay, and in the other videos that we made on this with Buckles, I don't know if we've posted it, Brian, but we've made one. And really, at the end of the day, what's the balance of probabilities is objective, as opposed to, oh, I prefer this guy or that guy's evidence. So, let me just find the right file that I want to share. Okay, so what I want to do is just take you through, first of all, really, what is ratio decidendi and obiter dicta or dictum. So people need to understand how this works so that you can understand your rights, because it's all about discrimination and treating people equal under the law. Share screen, screen 2, share. Okay. So I want to start with an explanation of the two differences so that you can actually start reading judgments and see learn to see what you're looking for. So basically, if I make this bigger, whoops, up, down. Okay. What is common law precedent, basically? Stare decisis is the principle of a decision applying equally to all. So this was introduced in the Norman invasion, really, and started spreading. And there's two types of stare decisis, okay? One is called horizontal. So people are saying that county court judgments are not binding, or magistrates court judgments are not binding. So what stare decisis says is a matter once dealt with, and then it becomes law for everybody equally. And 98th Monkey one of the issues is there were, I don't know, say for argument's sake, 1,000 liability orders in that case. In my magistrate's court hearing, it was a bulk listing and there were 2,500 liability orders. So the same breaches of simply not the court not following Nicholson and Ewing judgments in regards costs. And in my case, the judge overturned my liability order, i.e. they've admitted that the magistrates and legal advisor were wrong. Okay. That means that in the magistrates' courts, in all magistrates' courts must now do the same thing. And certainly in Liverpool, where my judgment's been set aside, because it was part of a bulk hearing, it means they need to set aside all 2,547 liability orders, not just mine, because the judge has overruled and said we made a mistake. That mistake applies to 2,500 liability orders. All right. And so this is, like I say, called horizontal stare decisis. A decision's been made that they didn't follow the rules of the game. There were 2,500 other people on the list, on this bulk list, and therefore that decision applies equally to every one of those liability orders. Should they not do that, they are discriminating. Socioeconomic discrimination by treating people differently under the law. Now, this should be used as a whip for the councils to make sure that they properly submit their costs for scrutiny. It should similarly go to the magistrates. You can't just sit, drink a cup of coffee and say hi to your mates from the council and just sign the liability orders. This is not acceptable. This is not doing your job properly. So I'll be pushing for them to get rid of all those 2,500 liability orders. And if they don't, then they're in breach of the fundamental principles of law, the rule of law. Now, a common law precedent, basically, if you imagine, I'll explain this more. I'm putting together, sort of the documents or some stuff for the constitutional courts. In the Norman invasion, you used to have moot courts and leftover from the Anglo-Saxon days and manor courts. So that each estate, the lord had his own courts to sort out his own business. But as the king got more organized, then the law was spread to be equal everywhere. And the reason for that is they actually started keeping records. That meant that you can have a decision and everybody can be notified about it, and then everybody must abide by it, thereby making the law essentially knowable and all equal under the law and nobody above the law. And then people still weren't happy with that because things weren't fair and just necessarily. And so, in effect, they had a circuit court or circuit judges that would go around with the king to go and visit all the local areas. And then that there, in effect, was the appeal court. So when people had felt there's an injustice, then they'd appeal to the king. So that there's sort of the appeal court. And when the king changed the law, the common law, that there again needed to be communicated all the way to all the courts so they could apply it equally over the country, i.e. a top-down hierarchical structure. Principal agent is the fundamentals of that. But that's the only way you can ensure that all are equal under the law and nobody's above the law. However, what also changed, okay, and this here is important. What does precedent mean? Essentially, precedent is the reasoning used to resolve the dispute. In effect, the mathematical formula that you apply to the same facts to get a consistent result. And that is what common law precedent means. So the precedent is the reasoning behind. When I was at school, I could get the wrong answer, for instance, in a mathematical problem, and I still could get over 90%, because if my reasoning to get to that answer was correct, it's just a simple error. But the logic is what's important. So the answer wasn't important. It was, did you understand how that answer was achieved? So that is called the precedent is the rule or the formula used to get the answer. Is everybody clear with what that is? Anybody got any questions on it? So orbiter is merely a comment in passing, and binding is the reasoning to get the outcome of the judgment. Now I want to go through some examples here using Leighton and Kofa judgment so that people understand it. Yeah, Robbie, you had your hand up.
I wanted to get full wind of what you're saying in your judgment. Are you saying there was non-disclosure? Because of non-disclosure was the incorrect procedure?
I don't know the details of non-disclosure. I didn't see an issue with that.
Okay.
But I'll go through. I first want to show people the difference between what are called, in essence, comments in passing, i.e. non-binding on other courts, and they are merely persuasive arguments, okay, as opposed to what is binding. So what I want to do is just start with, it's easier to see in Sharon's judgment. So I'll start with that. Kofa, this one. Okay, so what I've done is I've gone through the judgment, and we've been through this and we've made a video on it. So, but there's some other points which are very important in here, which hasn't really gone through yet. So basically here is a red box, okay? And somebody posted in the group that the councils wrote back quoting section 29, okay? So this here says some further observations. It's introduced, okay? I am basing my refusal of permission for judicial review squarely on alternative remedy discretionary bar. Therefore, this is, he's saying clearly, this is nothing to do with why I refused the judicial review. Therefore, this is not part of the reasoning to refuse the judicial review, but are basically comments in passing which he feels needs saying. And therefore, they're not binding because it's not a reason for reaching the decision. So this here is a persuasive argument, right? And this is the argument over the question of liability orders. What constitutes a liability order? So basically, he goes through and explains now, oops, 2021. Okay, so he starts off with the 92 regulations do not require a court-issued order. So that there really, now the issue is totally simple now on the court orders following this judgment and the Leighton judgment. It simply boils down to, what does the word make or made mean? That's all we're arguing about. So all the rest is irrelevant. Okay, the court will make the order. Rule 115 specifically excludes liability orders from the general service. 50 charging orders says made. You know, so now you need to learn to read what they're saying. I have been shown no provision which requires an entry in the court record to be sent or served on persons against whom liability order is made or enforced, or to be produced in the county court for the purpose of a charging order. What's he saying there? You guys haven't helped me. You haven't shown me what you want me to do to sort your problem for you. Okay? I have been shown no provisions. Okay, the next part then is the making of a charging order. Sorry, okay, let me make it a bit bigger as well so people can see it. Let me just move the screen. Okay, is something which could be treated as evidenced without necessarily pointing to an entry on a court record, at least in absent a direct challenge properly raised when a court is considering whether a statutory precondition has been satisfied. Okay, what he's saying there is, okay, the issue is how are court orders challenged? And we'll come back to the answer to this in the latent judgment. Okay, so he's now giving suggestions. Suppose the county court has before it evidence from a person who was present in the magistrate's court, who owes ethical duties to the court, and who confirms that a liability order was made and what basis that is being confirmed. i.e., our argument was, unless you were in the court when the order was made, then you're relying upon somebody else telling you. And this again relates directly to the latent judgment. Therefore, the only person that can testify to a verbal order is the people that were present at the hearing when it was made. Now, verbal orders are what's called extemporal, and it's common. It's a common thing in courts to give extemporal judgments, and this is fine in a court of record. A court of record, if you want to appeal, you can get a transcript and you can get a record of what the order was to evidence what was said in the court. However, the magistrates' courts are not a court of record. That creates a problem that the only evidence of that court order can be produced by witnesses who were present at it. And so this here really is the crunch of the matter. Okay, now what Buckle was arguing, and he provided the court with the HMCT guidance or Justice's Clerk guidance that made it clear what record must be provided. He provided the FOIs from the MOJ or HMCTS, I can't remember which version he produced, which said clearly, council documents are not evidence of a court order. They are council's opinion, council's view, council's interpretation, and is not a court document. So the judge, District Judge Cohen, was with this knowledge, yet he still chose to ignore it. Okay. So here he goes on, in his opinion, okay, this practice was discussed at Leighton, in Leighton's judgment. The judgment in Leighton concluded, based on extracts from the court list, paired with a signature certifying the number of liability orders made. Exactly the same situation as Buckle's case. The same documents, okay? The same, you know, a liability order signed off by a magistrate or whatever, who knows, because you can't read the name, and saying, you know, we've made so many liability orders, or in Buckle's case, the table contained, okay? So that the evidence set out in the documents, right, the same documents or equivalent documents were in Leighton's case as in Buckle's case, on the balance of probabilities, liability orders in question had been made. Okay. Now, if you go to the Leighton judgment and look at the context of that, I think it's in 19. Right. That there was a part of the decision of the judge. It was part of the reasoning. Okay. So here he says, what is relevant is I'm satisfied in the balance of probabilities that the magistrates court were granting liability orders against those shown in the list on the day in question. I.e., he's happy that piece of paper is saying 500 liability orders were made. Or in the equivalent of Buckles, he's happy that orders were made in accordance with the table. Beyond that, that document is worthless. Okay. And the counsel gave that to the defendants for enforcement. That actually is not correct. Oh, sorry, passed on that information. Okay, so they didn't actually give a copy. But here he says, I preferred the evidence set out in the documents. All right. Now, Buckle argued, he put across the points that we'd put on our skeleton argument and on the document. And that there is here. The reasoning, okay, is putting oneself in the defendant's position. They were being told by a public body that for enforcement purposes, liability orders had been obtained against individuals on a list for the purposes of paragraph 66(8)(b, that would amount to grounds for a reasonable belief on the part of the enforcement agent that there was in existence a non-defective interest. Okay, it was not, in my judgment, necessary in order for the enforcement agent to have a reasonable belief for him to go further and inquire how the order was obtained or process involved. Okay, so back to this. So what he's saying here is, on the balance of probability, the orders in question had been made. Only pertains to the reasoning why, in the Leighton case, he accepted that the up till that point, the enforcement agent could proceed on a reasonable belief in good faith, equity. Okay. However, if this was true, you must ask yourself, why did the court then give him $4 grand? And that's why you need to understand there were two different issues. So what the judge was saying is, to have a reasonable belief, you can proceed in good faith. And the reason that Leighton was awarded the damages, okay, was not because of the balance of probabilities. Right. Where is it? Sorry. Right, here it is. Okay. The reason Wayne got awarded was not under section 66, it was paragraph 26, a different section. Okay. And what that required was, when asked, they must prove authority under section 26, i.e., they were asked to prove their authority, which they'd commenced the enforcement on and are allowed to in good faith, i.e., carry on in good faith, but when asked to prove, you need to cease and desist. Okay, that's how this works. And here is showing you exactly how it works. Okay, so, and this was his reasoning. If a householder knows that an agent will visit, why should he not seek sight of any authority in advance? We send them our notice asking them to prove their authority as soon as we get notice of enforcement. From that point on, they must cease and desist until they prove the authority. Okay? There's no doubt Mr. Layton made it clear he wanted to see the defendant's authority to enter his premises. And whilst he may himself have focused on having sight of liability orders, it is not, in my judgment, sufficient simply to signpost him to the local authority. What are the councils telling us to do? Oh, if you want it, go and ask the local authority. The enforcement agent wants to enforce it. He needs to come with the paperwork. It's not up to you to check his work. He needs to prove his claim. You don't have to disprove it. They must prove their authority. Okay? In this case, and for the reasons explained above, we have no physical individual order that can be shown by the defendants to the claimants. He's simply told to contact the local authority. In my judgment, a householder is entitled to ask defendants on what authority they are purporting to enter his property. And the fact that they cannot do so and refer him back effectively to their client is almost bound to cause him to be satisfied. In my judgment, the defendants are in breach of 26, paragraph 26. Okay, so in the Layton judgment, we've got two precedents. Okay, the first one is they can proceed until they're asked to prove the authority. However, here you've got to read in between the lines. Okay, the judge is saying here what it is. Here the question is about a county court being satisfied, so this is directly applicable to Buckles, whether based on the council's generated printout, and Buckle made that point, or what it is told about what happened in the magistrate's court, or both, and all in a case where the individual does not attend the county court hearing to ask for some further inquiry. This is a direct rebuttal from the High Court to what happened in Buckles' case. The court has a duty of care to check what is being submitted. All right? And what is saying on the top here with this one is the only way that it can be evidenced is by somebody that was present. So this here, in the Sharon's judgment, is some further observations. This is not binding. However, like I've just shown you, the binding precedent for this is the latent judgment, because the latent judgment makes it clear. If you do not, you can't tell the person where you're collecting money, go to the court yourself and get the order. Nothing to do with me, mate. I'm just doing my job. That does not cut it. If they have to bring the order to you or evidence of the order to you. So this is the reasoning in latent judgment, which is the obiter or a passing comment, because this was in two different courts, okay? However, this here now means we have two judgments saying the same thing. And this here should have been applied because we talked about the latent judgment in the submissions. The judge was bound under this precedent and the latent precedent that Bakul should have won his application and the council's paperwork should have been thrown out. And the reason is, going back to stare decisis and common law precedent, which is our judicial system, the judge failed to follow precedent, which was within his knowledge, and we had submitted it to them, and he chose to ignore it. Okay? So this is why I'm considering we give the court an opportunity to correct its mistake based on its officers breaching their duty to the rule of law and to the court. And we give the court the opportunity to fix the problem of its agents not doing their jobs properly. But even worse, there was a barrister there, okay? The barrister should have pointed this out to the judge. The barrister's duties are to the rule of law and to the constitutional and to the court. And their obligation to the court is to put the court with all relevant law. The guy did not put the court with the knowledge which he was, because they also got a copy of the submittals, and he failed to tell the judge what the proper law is. Balance of probability only lasts until we've been asked to prove, and Mr. Bakul has asked us to prove, and therefore the documentation that was submitted by the council does not meet the burden of proof, and therefore, Your Honor, you have to throw out their application for a charging order. Okay? So, but basically, based upon these two judgments, it really has narrowed the issue. Simply, what does the word make or made mean? And today I finished my statutory interpretations course, and I'm drafting it up, and that there, I can tell you, is all that it boils down to. The word make or made. What does that mean in the Local Government Finance Act? And what does it, and was that intent expressed in the regulations? And they are buggered. They honestly, they really are buggered. Just with the latent judgment alone, they are. But now we're going to throw even more at them. Okay, anybody got any questions between ratio decidendi and passing comments?
Yes,
Ratio reasoning is binding, whereas passing comments are persuasive arguments. Sorry, Daniela?
Yeah, I've got some questions, please, because whilst I understood very well what you explained about the latent judgment, I'm totally thrown out now by the liability order and the fact that if you could put the first page up again with where it was other observations or something.
From Sharon's order, yeah?
Yes, yeah, other observations or other.
Okay, just hang on a second.
Because that really threw me out and kind of
Okay.
everything I've been building in my head is now collapsing.
Whoops, no, it should be consolidating, not collapsing.
Yeah, that's why. Because what you said about blatant judgment makes total sense, but we are past. Okay.
Okay. Right.
Leave. Yeah. Okay.
Okay. So
yeah, further observations, please.
Yeah. So let's just go up here and have a look what the guy said. So hang on, Ashby. Okay, so these are the constitutional things which is said that so the constitutional argument, he says, in its present format, he does not believe that it meets the threshold for a reasonable prospect of success. It's a modest one. He reckons, you know, you're on the right track, but you've got to really argue it better. And now this year, this second part, the House of Lords overturning the government's appeal for it, absolutely nails this, because that says the Commons, through their votes, cannot change the law. Okay, so it's really tightening that up. But that there is not why he threw it out. He discussed the liability order precondition. So for a charging order, it needs to be 50.1, which says a magistrate court has made one or more liability orders. That's the criteria, okay, that is needed for making the charging order. In the county court, they must be satisfied that the liability orders have been made by the magistrate's court. So the question is, what does the word made mean? Okay. And so what is said in the bottom was, in essence, made needs to be evidenced. However, this wasn't sufficient to throw out the thing. But what he was doing here is leading up to the appropriate forum, because for judicial review, you need to explore all alternative avenues. Judicial review is a last resort. And so he's listed the alternative remedy to go to appeal. He's listed the alternative remedy to set aside. Okay? And he's explained what is the discretionary bar of having explored all alternative remedies. And then he said, the council quite rightly questioned whether this threshold had been met. And then he said, in my judgment, it's appropriate, in my judgment, and in this case, inappropriate to allow judicial review to be used by Sharon, who has failed to take advantage of procedural rights by which she could have raised the issues about liability orders not having been made. It would be contrary to the interest of justice and public interest if such points could be reserved for a later High Court challenge by judicial review. The primary forum they should be considered subject to further appeal is the county court, i.e. go back to the county court and re-argue these issues and don't waste the time of the High Court. So he's explained the reason why he's dismissed the judicial review. However, he has not addressed all of the issues that Sharon had. And therefore, he's just made some further observations. Some of the other things Sharon was talking about, okay? It's right, okay? It's right in the light of what I've read and heard to make some observations identifying difficulties with her arguments on liability on liability orders may face. Okay, so in effect, if he had to make a judgment on it, this is what reasoning he would use. Okay, so and then this here is arbiter, it's opinion. It wasn't used in the decision making for throwing out the judicial review application. So if we scroll down a bit more, here's the costs. And this people really need to pick up their ears, okay? This is a precedent, okay? This is telling you a lot. The principles for judicial review are found there. There's no good reason why Sharon should pay these costs, but also no good reason why the council should recover them on an indemnity basis. And that there is for the summary grounds, acknowledgement of service and summary grounds, okay? He's saying for this, they're entitled to costs, but not on an indemnity basis, okay? I will reduce the costs from 3,000 to 3,250 from 3,968. Okay. This here is what's called a summary assessment. The judges just summarily assessed it, and the council can challenge it. However, there should be no order as to costs of the hearing. That's the default position in judicial review. It enables people to know where they stand, absent some good reason for departing from it. Okay, Sharon persisted in her arguments, which did not prevail, but there was not a certificate saying that she's wasting the court's time, totally without merit. Okay, that puts her into the default category, and therefore no costs, whether she wins or loses, are applied for the oral hearing. However, this here is very, very important for us. A skeleton argument was put in by Ms. Khan, the barrister for the council, but that can hardly justify the costs order. They wanted another £4,000 for this skeleton argument. The only point it developed was as to whether such cost orders should be made, i.e. she totally put nothing in regards to the challenge. All they were concerned about was getting paid the 4,000, because that's the only threat they have. Okay, and this here is the argument of reasonableness. They can only award reasonable costs. And therefore, this here is the basis of all our arguments going forward. Well, we told them we understand how council tax works and the intent of Parliament. They don't need to regurgitate 3/4 of the Local Government Finance Act, because we've already told them we know that, i.e. they are creating costs, and those costs are not reasonable because we're in agreement over it. There's no argument. Okay, so really the whole cost aspect, because they're trying to really, with section 142s, threaten us with costs. Everywhere they're threatening us with costs. So with the costs, it comes down to reasonableness, and that reasonableness is basically, if you've added nothing to assist the court to resolve the matter as an officer of the court, why the hell should we pay you? That's what this guy is saying, quite correctly. Okay, win or lose, it's always at the discretion of the court. That's why we act in honor, good faith, clean hands. We go through our pre-action protocol. We send the 3 notices. Okay, we give them the opportunity to remedy, so that by the time we go to court, win or lose, then we've done everything humanly possible to try and resolve the matter. So do you see how this costs here is ratio? It's got an explanation, the reasoning as to why he reduced the initial costs down to 3,250 and why he gave them nothing for this hearing. Is that help explain it, Daniela?
No, because that's not what I was asking, Mark. Sorry. What I was asking is where they say that a liability order should not be made by the court. This is what threw me out. On the top of the page, it says a liability order should not be made by a court.
Hang on, which page are you on?
That very page you are on.
Hang on, let me just share the screen again, and you can just take me there. This part?
Yes, there. Stop there, please. 29.
29.
The 1992 regulations do not require a court-issued order.
Right. Okay, and that there simply comes down to the interpretation of what does the word make or made means. In the regulations, okay, and also is wording, and going back to how the questions we asked, okay, we've got to go back to the submittal, because maybe Sharon used the words court issued order, okay? And that there we can actually check because he's got the summary. Here you go. Okay. So she was arguing, and we've got to check our submissions. Okay. In this case, no, using then quoting Sharon's words, court issued order has been produced. All right. So what he's saying is down here, I've not been taken to any regulations that the court must issue an order here. Okay. I have been shown no provision which requires. But this here now is talking about a court record.
Exactly. So this basically, we have built our arguments on the fact that what the council was sending us was not right, because either it wasn't the right memorandum of entry, it was just a paper from the council, etc. So now what it's written here on this page is basically, we can't argue this anymore because...
No, absolutely we can. We've got to argue it in a different way.
So in what way should we argue that? Because, for instance...
Very, very simple, okay? Who is the Local Government Finance Act and the Council Tax Admin and Enforcement Regulations aimed at? What's the target audience of them?
The public.
The public, right. What does the public understand in the normal meaning of the word make or made? Speak? I don't think so. A reasonable person who's left school in England understands the difference between speaking and making. Making means you're making something. That means it's something physical. Speaking, if Parliament was happy just for them to speak the order, they would have said so. They wouldn't have used the word make. They would have used the word speak. Okay? So a reasonable person would understand Parliament's intent. Like you said, the target audience is the public because it's a public act. They need to use language the public normally use and understand. There's a big difference between the word speak or spoken or verbal order and making an order. Okay? And it goes beyond that. So that's one of the ways to present the argument. Then another way to present it is this. Okay, the Local Government Finance Act says So the Local Government Finance Act is the primary legislation, okay? So if we go to the order, right, this is the statutory instrument which removed the Form A and Form B for a liability order, okay? So here,
You're not
in
sharing
section
the screen.
35.1, okay,
You're not
Form A and Form B, yeah? Oh, am I not sharing? Sorry.
No.
Thank you. Okay. So this is the 2003 regulations which removed Form A and Form B. Okay. So in regulation 35.1, omit the words. Okay. However, it also says in regulation 48.1, omit the words Form C. And it says omit completely Schedule 2. So if we go here into the admin and enforcement regulations, we're all familiar that 35.1 and 2, okay, 35.1 relates to Form A and Form B of the liability order. But remember, which one was on? It says here in regulation 41, omit Form C. So what the hell is Form C? Okay, so if we go back to the regulations, 48.1, okay, is Form C. And that is for commitment to prison. It's for a warrant. Now, do you really think, okay, so let's just look at forms, what a warrant should look like. Okay. So all of this schedule is deleted. Form A, Form B, and Form C, a warrant for commitment. So if they're saying the intent of Parliament is not that a physical paper document is needed. Firstly, a reasonable person understands the difference between the word make and speak or spoken. Okay. And this intent was fully understood by the Secretary of State when they made the 1992 regulations. This here is a physical form, this is a physical form, and this is a physical form. For them now to argue and say, this and this one, Form A, okay? Oops, how do I go back? And Form B don't have to be physical forms. These two can be spoken, okay? So explain to me, with a warrant, do you really think that an enforcement agent coming and saying, oh, the council said there's a warrant for me to commit you, I'm going to remove you now. Do you really think that's going to work? Absolutely not. But Form C was also omitted, together with A and B. All right. And it's clear that all that they're doing is saying you do not need to use this format. It cannot be construed by a rational person to mean anything other than that.
So why do they say at 29, I have been shown no provision which requires an entry in the court record to be sent or served on person against whom a liability order is made or enforced? Or to be produced in the court where you have it in green. This is what throws me out.
The latent judgment says you can go by the council's word in good faith until you ask to evidence it. The only way that a liability order can be evidenced is by first-hand witness testimony of those present at the making of it. Nobody else can say, yes, I heard, you know, the liability order was made in my presence. I swear to God, the truth on it, and all of that stuff. Without any evidence of a physical record, okay, having been made of that fact, it's impossible, other than for the person that witnessed it being made, to verify its existence. Now, basically, if you weren't present, you won't know about it. All right? So how the hell can anybody prove it exists if they don't have a record of its existence? The only way it can be proven to exist is by somebody that witnessed it being spoken into the court.
I understand that, but what he's saying here, it's not even necessary. This is what I don't understand.
No, he's not saying that. Latent case says, when I ask you to prove, to evidence it, you need to do that. Okay, the latent case is absolutely clear on it. There's no question about it.
No, I understand now. I totally understand about latent. But looking at what you have highlighted in green from Sharon's on 29, what throws me out is the fact that the judge says, I have been shown no provision which requires an entry in the court record to be sent or served on person against whom a liability order is made or enforced.
Yeah, what he's saying is, we didn't show him. We didn't argue it. He's not saying it doesn't exist. He's just saying, with the evidence presented before me, you know, I've seen that evidence, so I can't make a judgment.
I see no provision. That's not what I understand, but I might be wrong.
No, I have been shown no provision. Nobody's shown me. It's very clear what he's saying. Nobody's shown me that there requires an entry in the court record to be sent or served on person against whom it is.
Okay, so if you or Sharon would have shown that provision,
then he would have had no problem with it.
Okay, I see now. All right.
Yeah.
Does that mean that we need to not attend courts?
Okay, it's an interesting one. If you attend the court, you were present. However, you don't have to assist them to prove its existence. They still need to prove its existence. Because, I'm sorry, I can't remember the number of liability orders that were made in my case in the bulk hearing. I don't know. I don't know in each of those 2,500 liability orders, was it £100? Were they, you know, £80 like mine? Was it £1,000? I have no idea. So it's a bit like my birth is based upon hearsay evidence. I don't remember any of my birth. And it's a wee while ago, so I honestly can't say that I remember exactly what happened. Nor can they. But it doesn't matter, because there are other ways. There needs to be a court record. Without a court record, they can't enforce it. Under Rule 66B, okay, there are...
Sorry, by the way, 66B of...
Magistrates' Court Rules.
Okay, and just for the record, because I'm trying to find it, section 54.1 and 51.1, or whatever it is. What is that of?
Let me just take you to 66B. So 66B, request for information. This is anybody in the public, okay? So this is the Magistrates' Court Rule 66B, request for information about case, including a member of the public, okay? So the information they must hold on the record as a minimum is this. Okay, what does this say? the date of the hearing, the general terms, in general terms, the subject of the preceding council tax hearing, the court's decision, whether the case is under appeal, the identity of the parties. So the parties, the identity of the parties' representatives, including their addresses, and the judge, magistrate or magistrates, or justice's legal advisor by whom a decision at the hearing in public was made. It needs the magistrate's names on that. So this is available to any member of the public. Therefore, a county court to authorize a charging order, this is the minimum duty of care they owe to the public. If the public have access to this, the county court, as a minimum, should have this information before making a charging order.
Can I ask?
Yeah. Sorry, just remind you your next question. Just hang on. Yeah, Robbie.
Buckles made this point clear to the judge, and I've got to give him.
And the judge ignored him.
No, the judge ignored him. But am I correct in saying that when accepting a signature without authentication of who that person is, the judge was double wrong?
Oh no, but the Buckles case is just a disaster because nobody actually put a statement of truth to what was submitted to the court.
This is what I'm trying to get clear. With the signature that was on that piece of paper saying it was a liability order, the judge accepted it without knowing who the person was. He said,
correct, exactly what I'm saying.
I accept this signature as a person of the court, but he has no proof of that.
And that's what Buckles said, and the judge ignored it.
Exactly. This is why I said he wound his way out.
No, he breached his duty of care.
That's what I meant to say. Yeah.
And he breached his duties as a judge. Yeah. There's no two ways about it.
Yeah, Buckles pointed that out.
Correct. A number of absolutely. Sorry, Hugh, what was the other section you wanted me to go to? 54. You muted.
Section 54.
Of which paper?
That's my point. I don't know.
Oh, where did I talk about it, or is it in the judgments?
Yes, it's in Sharon's judgment.
In Sharon's judgment,
no limit. Yeah. There's no limit.
Yeah. This one here.
Yeah.
Okay, so 54.4. Okay, basically the word "made" is not only for distress. It's also in section 49, which is for insolvency. So the same problem arises under if they want to make you insolvent. The same problem applies if they want to get joint liability. But basically, for any enforcement, the latent judge applies. In good faith, you can accept the council's word, okay? And because that there's a reasonable belief in good faith. We accept people act in good faith, and therefore, if I tell you I have authority, you can act in good faith, so you can stand on your believed right, but good faith ends when somebody asks you to prove your authority.
Okay, I've got that, Mark. But what I'm after, he mentioned in his judgment that she had failed to take advantage of
section 54. Alternative remedy, this one here. Yeah.
Or 51.4. Okay.
Yeah. Okay. So let's just go. And
where is that?
The County Court Act, I'm guessing. Hang on a second. Let's just pull up another one. You can just pull up another. Yeah. Okay, so I think that is County Courts Act 1984. Yeah. Okay, just remember 50 subsection 4.
51.4. 51.4.
Okay. There's no damages, no. No. Was it 51.4?
Mark, it was a regulation, so I don't know if it's going to be an act.
Okay, so it's maybe then the council tax regulations. Okay, so let's go up here and see if it's in here. Charging orders. Yeah, it's probably in this one. 51, yeah?
It's 51.4, yeah.
Okay, so 51.4 in the council tax regulations say at any time on application of the debtor, you can ask for it to be set aside.
That's the one. So that is, which one is that?
Any time. 51. So this is council tax admin enforcement regulations 92. So at any time, we can have these things set aside. So what we need to do is, and we'll test with Buckle's case because he's happy to proceed, we'll put forward our revised arguments, including the duty of care, which in Sharon's case, the judge points out, being that as a minimum, it should have the information on that is required, that the public have access to. That's an absolute minimum that should be on there. It should have the justices' names and the parties' names, etc. If their Libra system is not adequate to meet that requirement, okay, then there's a problem. And the normal meaning of the word order, like he said, in the county court, this nonsense wouldn't occur because we make proper orders. And basically, it can be a written order which must be served. Now, imagine you're out the country for 3 months, you know, traveling or whatever. You get a summons, you get a liability order, i.e. you're not present at its making. How do you have any evidence of this? You wouldn't even know about it. Okay? It's irrational to think that it can be simply spoken when you haven't got a court of record. From a court of record, first word to last word spoken, you can listen and type the order,